There we go. Thank you. And then I'm going to go ahead and share screen. I'm going to share some slides as we go through this. I'm going to try to do my best not to actually read the slides. I know that's a really annoying thing that some folks do. So you're at the right event if you think you're at the new Lake District Commissioner orientation. This is the first time we've offered this, but we wanted to have a time more specific for maybe people who just newly were appointed by a local government to be involved on a lake commission, or maybe you were elected last summer and you're still trying to sort out exactly your roles, or maybe you've been part for a while and you're still sorting out your roles. So we're going to focus on the basics, but then in the Q&A, hopefully we get into some of the stickier questions that you might have about lake districts. Our office, Extension Lakes in Stevens Point, has been doing this sort of thing for almost 50 years now. Ever since Chapter 33 of Statutes was created, there's been a role for Extension to try to help communities navigate Chapter 33 and set up their lake districts and try to keep them on the rails. So again, I play a piece of that role, but I'm really thankful for people like Mike and Dan, and really all of you for being participants in the Lakes Partnership. So a key thing about lake districts is that they're governed by state law. So lake districts are units of local government regulated by statutes. And you don't, as a lake district, as any local unit of government, you don't get a lot of latitude or kind of range to just roam around and do things however you want to. You do have to follow their statutes. They're fairly prescriptive in many ways. We'll talk about some places where they're not too prescriptive. The link that I posted up there, you can also find this just by Googling Wisconsin state statutes. The online version of the Wisconsin statutes are pretty much the most current version. So we always recommend people kind of use their web page or use their web browser, find this link, go to Chapter 33, and maybe even bookmark that, because you might always want to go back to Chapter 33, see if you've gotten things correct. There's a good chunk of Chapter 33 that's really just specific to inland lake protection and rehabilitation districts. That's the long name for lake districts. And so those pieces of statute don't apply to like towns or cities or villages. It's all custom written just for lake districts. Much of it is fairly specific and drills down to a lot of details. And because of that, we have really felt for the longest time that lake districts don't need to create separate bylaws to govern themselves. If you had chosen to create bylaws, or if you have bylaws, remember they can't really be in conflict with Chapter 33 because the state statute would overrule your local bylaws. And we feel that the chapter itself details out enough specificity that you should be able to operate with that. And Chapter 33, even though it fits within all the laws applying to local government, it really can drill down into very specific things that towns, cities, and villages don't need to worry about. On the same slide, I talk about how there's other parts of statute, particularly Chapter 19, that you may need to pay attention to as a commissioner. This is where you would find things about the Code of Ethics, open meetings law, open records requirements. Lake districts have to follow these as well. Right, so they're not specific to lake districts, they're specific more to all local government service. And some of you, if you're an appointed member, if you are part of a county board or part of a town board, these same rules would apply to you there as well. The statutes kind of give a broad set of powers to lake districts, but they're really not that broad. Most of what a lake district does is really around managing money and raising money. When the Lake District Law was passed, it was really designed to help citizens around lakes who wanted to take a more proactive role in caring for their lake, but they struggled to raise the money needed to carry out what needed to be done. And so they found themselves holding fishing tournaments and bake sales and knocking on lots of doors, trying to raise money. And they found that they were spending all their time doing that when really they want to spend their time and energy actually taking care of the lakes. So the Lake District Law is primarily set up as a way to raise revenue needed to take care of lakes. But you can see in this list of different things that you can do or that you have the power to do as a lake district. And that last one, take other acts necessary to carry out a program of lake protection and rehabilitation, kind of gives you that broad, a broader sense of what you could do as a lake district. But it still has to be specific to a program of lake protection and rehabilitation, which is kind of what keeps you from starting, say, a K-12 school system. That's what we have school districts for. So the lake district focuses on lakes. There's two big pieces of governance involved here. One of them is the one that we're talking about today, which is the Board of Commissioners, and the other one's the annual meeting. And we're actually going to spend more time talking about the annual meeting next week. So I'm not going to spend a lot of time today talking about it. But here, this slide kind of describes that the commissioners are essentially the day-to-day governance body for the Lake District. But at the annual meeting, it's the residents of the district and the property owners in the district who kind of rule the day, and they set the budget, and they can also do other things to sort of set the sideboards for how the board is going to operate in the coming year. And as the name suggests, it's every year. So there's always going to be an annual meeting, always an annual check-in with these folks, the stakeholders, to find out if you're on the right path. There can only be either a 5-member board or a 7-member board for a lake district. There's no such thing as a 3-member board or a 4-member board. There's no such thing as an 8-member board. Statute is really kind of really specific about this. Most commonly, we find a 5-member board. And so that would have you hosting 2 appointed commissioners, as well as 3 elected commissioners. And the elected commissioners would be serving staggered terms, so that every year there'd be 1 person up for election, going kind of every year forever. We'll talk a bit about appointed commissioners in a little bit. At an annual meeting, the property owners and residents of the district can say, you know what? Let's add 2 more elected people to that mix. Let's go from a 5-member board to a 7. I'm sorry, yeah, from a 5-member board to a 7-member board. If they do that, that's a one-way change, in the sense that you can't then at a future annual meeting vote to go back to a 5-member board. Statutes only allows for a one-direction change, and it's towards the larger board. So I mentioned elected. If you are amongst these elected folks, you're serving a 3-year term. The ballot is required at an annual meeting. It's supposed to be a secret ballot that's specific in statutes. Even if there is not a contest, there should be a way for the people who are at an annual meeting to vote by secret for the commissioners they choose. Amongst those elected commissioners, whether it's 3 or 5 of the elected commissioners, vacancies are filled through an appointment to the conclusion of the term for which the person was initially elected to. So if someone were to move away from the lake after serving 1 year in elected term, that term then would be filled by an appointment for the next 2 years, so that it would be regularly elected sort of on cycle. And that appointment is nominated by the chair of the Lake District, and then subject to an approval vote by the remaining commissioners. These are sort of the qualifications to be a commissioner. There's some nuances here. For the most part, you have to be the same kind of thing you'd have to be to run for any local unit of government, a US citizen who is 18 years of age or older. Typically, if you want to run for school board or town board, you just have to live in the school district that you're running for. That's true with lake districts, but you also get to vote. You also get to run for office if you're just a property owner in the district. So we could have elected officials, and in fact, we do have elected lake district commissioners who they primarily reside out of state. They primarily reside in Illinois or Minnesota or elsewhere. And so again, they're eligible by virtue of the fact that they're a property owner. A person eligible for election can also be an appointee. of a corporate ownership. So that's this last part here that says an official representative of an organization that owns property. So for example, if a local unit of government, or this is probably not a good example, let's just say a trust, it's a family trust, there's who knows how many people involved. If they designated Mike Engelson to be their appointee and Mike Engelson is agreeable to it and wants to run for the board, and he gets the most votes, then voila, Mike Engelson can be on the board, even though Mike personally doesn't own property in that district. He was selected by a corporate owner to be their official designee. This last one is a little tricky. The law wants someone to be on this board who lives there, who's a resident. But it also recognizes that a lot of lake districts are formed in sort of vacation country or cabin country, where amongst all the properties on the lake, there may be very few people who are full-time residents. And it would be a lot to put on those folks if this system of governance really demanded that one of them step up and be a commissioner. So it does give you a little bit of an out that says, if no resident is willing to serve, then that residency requirement can be waived until the end of that term. But we're looking for someone to be a resident on the board. I mentioned before, Chapter 33 does give fairly prescriptive sideboards for how to operate. One place that it's not super specific is really how to run these elections, and that has caused some issues. And you see on this slide that those issues maybe around how elections should be run has caused some people to say, well, let's get a little more specific about running these elections. But for the most part, you can't. There's no such thing as absentee ballots for the Lake District. There's no such thing as proxy voting for commissioners. You have to really be there in order to participate, and that creates a lot of challenges during a pandemic, which we'll talk about again next week. And 33.305, the reference at the bottom here, basically talks about some specific steps to take when you're doing the election for commissioners, including some real specific language around how a recount process could be handled. So prior to a couple of years ago when this law was passed, we didn't really have any guidance on how to do a recount. This piece of statute does give you a little bit more guidance and instruction on how to handle that. That covers mostly the elected commissioners. Some of you may be appointed commissioners, and you're going to come either from a local town, city, or village, or you're going to come from a county. And when a lake district cuts across multiple municipalities, which it can include a town and a city or multiple towns, we use the amount of valuation within the district to choose who gets to be appointed. There is one little sort of asterisk in the statute that says it's related to a town owning a dam or a local unit of government that owns a dam on a lake, that they may get the ability to overrule this appointment process if they're the town with lesser valuation, but they also happen to own a dam. So that's a very specific and narrow thing that really we know it applies to Lake Mason that cuts across, I think it's the Columbia County and Adams County line, but there's not a lot of places that are like that. And then the county, if you cut across multiple counties, it's the county with the most valuation that gets the appointment power. And that county appointee has to be nominated by the Land and Water Conservation Committee, and then it's ratified or blessed by the county board. They might not be property owners. We'll talk about that in a second, because the town appointment is a little bit more onerous in terms of describing who the town appointee could be. Local government appointees, though, these two folks who get appointed, they have the full voice at these regular quarterly or monthly meetings of the board. They're full-on commissioners. So they are eligible to be officers of the board. They can make motions, that can do everything that you could do at a regular board of commissioner meeting. There's no reason to think of them as ex officio or somehow not fully empowered to be board participants. So keep that in mind. The caveat here is that at an annual meeting, they do have to meet some specific requirements. So if they are an appointed commissioner who neither owns land in the district nor resides in the district, then at an annual meeting when the budget is being decided and when they're voting for the elected commissioners, those appointed commissioners do have to step back and they can't participate fully in what happens at the annual meeting. There was a change in the statute about 6 years ago about the town, city, or village appointee. Prior to this change, the town, city, or village appointee really had to be a member of that governing board. So it had to be a town board member, a village council member, or a city council member. And that got to be a little much. Like imagine if a town had multiple lake districts and a limited number of people on the town board, they all were choosing amongst themselves who's going to be the appointees out to the lake districts. And so they modified the statute to allow for non-board members of the town board to be appointed. And in this case, the way the law was written, they have to be a resident of the district, so they have to live there. That's the first test. And then secondarily, it would be ideally someone who owns property in the district. So they don't necessarily need to be a property owner, but they do need to be a resident, which again, in rural vacation land, that may be challenging sometimes to meet. And if that can't be met, then it falls back on the town board then selecting from amongst the town board members who's going to be the appointee. So the county appointee you can see is kind of similar. It's either a member of the Land and Water Committee or someone nominated by that committee, which actually broadens it out pretty much to just about anyone in the county, as long as they, I think, are 18 years or older and a US citizen and reside in the county and can make it through the gauntlet of being nominated by the Land and Water Conservation Committee and then approved by the county board, then that can they can serve. A lot of counties are really stuck in this idea that maybe that the county board themselves need to fill this role. There's good reasons to have county boards on there, but there may also be good reasons not to have county board members on there. It really varies depending on the situation and the county that you're in and the situation you find yourself in. So we do encourage people to look at, particularly if the county appointee rarely comes to the meetings or the county board just is struggling to actually live up to these obligations, it may be a good idea for other members of the district board to approach the county, maybe to the Land and Water Conservation Committee, and suggest that a non-county board member may be more useful, maybe more helpful because they come to the meetings. Those appointing members, again, can be replaced by that appointing body. Usually they follow their own policies and procedures. This can vary depending on the type of county that you're in. So some counties have a county executive, for example, and they may have internal process by which the county executive makes these appointments and the people serve at the pleasure of the county executive. Other counties, it may be fully dependent on the county board itself. And if someone were to vacate that position, let's say the county appointee moves out of the state or out of the county, then it's that appointing body that nominate or that places someone back into those seats. Statute is prescriptive about these 4 bullets. This is sort of what you have to do as board commissioners. You have to meet at least quarterly is what the statute says, not including the annual meeting itself, which is a fairly discrete and separate thing. You have to manage the day-to-day activities of the district. The board is totally responsible for scheduling this annual meeting and proposing the annual budget that's going to be voted on at the annual meeting. So really thinking about the annual meeting as part of your cycle of existence, that ought to shape a lot of what you do at those other quarterly meetings, which is like tracking the finances and paying the bills in between. As commissioners, you're not required to take an oath of office. You can, and we provide. This slide here makes a reference to page 95. That's from our online guide, People of the Lakes. It's a PDF guide that you can download. You could also get printed copies from us. But you could have an oath of office, but you're not required to. What we do want to stress, again, and this meeting is a good time to stress it, is you're important. You're actual government officials, right? So you're going to be expected to really step up a bit when you're a commissioner. You're no longer just a nonprofit board member. You're no longer just a property owner in the district. You have a government role. Amongst that board, you all get to select your officers. And a point I want to make here is that sometimes I've seen districts that fall into a situation somehow where they say, well, the chair position is up for election this year, as if they have like a chair position that comes up every 3 years. And that's not really how it should work. Every year when one new or maybe 2 new commissioners get elected to the board, immediately following that, there should be like an organizing meeting of the board to select the chair, the treasurer, and the secretary. So don't fall into the habit of thinking that somehow one of the elected positions is the secretary, and that only comes up as a secretary election every 3 years. The officers can change every year. Another point on this slide is that the Lake District commissioners themselves may feel overwhelmed. You know, again, most of you are going to get minimally, if at all, compensated to do this, and you may feel like you're out of your league. You can create these other positions like a recording secretary or a bookkeeper. You can even budget for them and compensate those people. Those people are not commissioners though, so they don't get to vote at the commissioner meetings. They're simply there as your hired help, let's say.
Hey, Eric, if I can break in, we've got a couple of good questions that are related to some previous slides that would be worth discussing, if that's
Sure.
all right.
I have a hard time keeping up with the chat, so I'd appreciate your co-pilot here.
Mark B asks, if a town appointee is also a landowner, can they represent themselves as a private landowner, or can they only give viewpoints as represented by the town? A
little bit of both, I'd imagine, is what really happens, right? So the town can unappoint them at any point that the town feels unhappy with whatever this person is doing. So if the town appointee, if the town board chair feels like this person is not voting in a consistent way with what the town would like, then that person sort of runs the risk of, I think, getting unappointed. And at the same time, right, as a property owner, they'd have a hard time totally detaching themselves from their own self-interest. And so potentially that takes place, right, that they're conflicted. Yeah, so I would say they vote in contradiction to what the town is interested in at the risk of being unappointed.
Yeah, I think it really depends on the town, what the town wants, really less than what the district wants. It's the district law is relatively quiet to it.
Yeah.
Dan Zimmerman brought up the age-old question that always comes up of if a board has no district resident currently serving, a district resident wishes to challenge the non-resident incumbent for that commissioner slot, does the resident win by default? Technically, I think that's what the statute says, right?
Yeah, and we have talked to Attorney Bill O'Connor about the same kind of question. He can't point, nobody can point to something that says, oh, here's the case, it was settled. We know exactly how this would play out.
Yep.
There's no such record of that. But he said that if one of the candidates did satisfy the resident requirement and the other candidate didn't, then technically the other candidate isn't qualified, is the way he put it. That they don't meet the qualifications to be elected in that cycle.
At that point, yeah.
I would, this is Dan Butkus, I would add that you have dueling state statutes because under election law, there is the statement that plurality wins. So if you have a non-resident who has the majority of votes and a resident who has the minority of votes, which statute takes precedence, chapter 33 or chapter 6 election law? Right. So, you know, my answer to Dan in the chat was, I feel the same way he does. However, it has not been decided in a court.
Yeah, and what Bill would say is that other candidate is unqualified to run even. So it doesn't matter if they get the most votes. If that other person was 17 years old and they got the most votes, we'd say, well, I'm gonna look at qualifications at the age of 17, they're not qualified. So sure, they might have somehow got the most votes, or maybe they meet none of the other qualifications. They're not a landowner, they're not an appointee of a corporate landowner, nor are they a resident of the district. If they somehow got on the ballot, you'd say, well, they got the most votes, but they weren't qualified. And so Bill fell back on the qualification language to say they were an unqualified candidate for that election.
And Dave,
Hey, Eric, Mike, this is Dan Zimmerman. I think there was a little bit of a misunderstanding of what I was asking there, or at least the way Eric was explaining it. The individual that's in the incumbent in that position is qualified to be on the board. They're a property owner. So they qualify to be a commissioner on the board. It's just that one happens to be a resident of the lake permanently, and the one that's a property owner is not a permanent resident. They're qualified, so they'd be serving, and they serve legitimately. So it seems to me that there should be some kind of an election, because there's nothing in chapter 33 that says it's an automatic appointee if the person runs. So that was the other part of what I wrote into the chat, but
Yep. So I'll go back to this second bullet
legitimate.
here.
Say again?
The second bullet on the slide that I have up right now talks about at least one commissioner must be a district resident unless no resident is willing to serve. And so what Bill said is, well, if you have a case where a resident is willing to serve, then you have to satisfy this resident requirement. And so if that resident who's qualified is in an election and there's no other resident running against them, then the other candidates aren't qualified because you haven't satisfied the resident requirement. That's the way Bill explained it to me.
Well, I don't know what, like on our, like, people would say, well, what if that guy's crazy and doesn't deserve to be on the board, but
Right.
just happens to be there and he lives there, and now we got to put him on the board. I don't think that's the intent. So, but anyway, yeah, I appreciate the breakdown of the question. Thanks.
And I think overall, the intent of this is to try to say out of those either 3 or 5 elected positions, try to get one resident in the mix there so that you have that resident, because you don't want to fall into the situation where it's sort of like, we have no residents at all. And so all it takes now is just one resident who wants to run, and they may be able to argue that they, I don't want to say win by default, but when they're up for election, that you need to run another resident against them in order to satisfy the resident requirement.
Yeah, what we do is we'll always ask for residents first if we don't have somebody on the board already. We ask for a nomination. Usually if there's one nomination, nobody else will want to run. So it kind of clears it up. But we did have one situation where a resident was running against a non-resident, and we held the election, and the resident lost.
Yeah.
Eric, why don't you, Dave Rip has a question. We'll hold that a little while so that we can get through the rest, make sure we get through everything else. Why don't you go ahead?
Sure. I just have a few more slides. So again, the board selects among, I mentioned this earlier, there is no sort of chair position that rotates around. You select your officers. This one's kind of, some can be important. I really don't know of a whole lot of boards that have a stipend that they budget for and allocate to the commissioners, but the statute is set up to allow this. There's sort of 2 sentences here that are pulled almost, I think, directly out of statutes. You can be paid the actual and necessary expenses you incur. So sometimes people think of that as like per diem, mileage, or things like that. It's just sort of a nominal amount. And then you can also establish compensation at an annual meeting, which means that the taxpayers, the property owners, and the electors have to be the ones who approve that. This is just to, again, flesh out a little bit of what the board is up to. I mentioned already, just knowing about that annual meeting and trying to build your board's life around it, that's going to consume a lot of your time and energy, because there are very specific requirements about developing and printing the agenda and mailing it out to every property owner in the district. That agenda has to include the proposed budget itself, and statute is pretty specific about what that budget looks like. And we provide examples in People of the Lakes to show you how you could fit a Lake District budget on one side of a 8.5 by 11 piece of paper, because it has to show sort of where you're at in the current year budget and then what you're proposing for next year. In addition to mailing out the agenda, you do have to give other public notice for the meeting. And this is something we'll talk about in a Lake District Treasurer's workshop coming up, but there's an audit requirement. It's not a highly rigorous audit requirement, but it is mentioned in statute that someone has to review the finances and present that at the annual meeting. So getting those things in order kind of shapes your life outside of the annual meeting. Then the meeting itself, the board plays a role, and usually the chair takes a sort of a lead role in actually organizing the annual meeting when it's happening. Also in between those meetings, just a matter of tracking the finances, approving bills that need to be paid, checking in on how expenditures are going, checking in on the projects that you're funding. Special meetings are sort of like an annual meeting. It's another opportunity for landowners and residents to steer the district's direction, if you will. Sometimes the board calls special meetings because they really want to hear from everybody what's going on. There's also a way in statute that the residents themselves can petition to cause a special meeting to take place. So just kind of tracking that and knowing if there has to be special meetings, filling in vacancies that may occur along the way. And then again, statute says try to meet, or statute says meet at least quarterly. When I say try to meet, I mean like if your winter meeting, your December meeting happened to coincide with a 4-foot blizzard that made it impossible to get to that meeting, you may not meet on exactly a 3-month cycle. You may have to push that meeting back due to the weather circumstances. But to accomplish these other bullet points, you can't really just meet once or twice and then say you're done. There has to be sort of a lot of material going on for the board to pay attention to. Those quarterly meetings themselves are public meetings, so please pay attention to that. They should be in publicly accessible places. This gets hard depending on how rural your Lake District is and how small the district is. It may seem hard to get a public location, but we stress, think of this again as something like a town board meeting. If you can, potentially use the town hall, a nearby town hall for these meetings. We'll talk about this a little bit next week, but local governments like your town boards do have the ability to meet virtually. That ability was sort of expanded a bit due to the coronavirus pandemic, but I think it's also being expanded really in recognition of how far along technology has come. I mean, right now we're holding a meeting with 27 folks gathering from who knows where. Some of you may be out of state right now. The technology has come a long way to provide for distance participation in meetings. In the case of lake districts, this may be extremely appealing because so many of the commissioners may actually not live or be at the lake all the time. So virtual participation at a quarterly meeting makes more sense. Secretary is a sort of a public official that needs to keep track of those motions and votes, and those are all public records. Chapter 33 explicitly says 3 commissioners constitute a quorum. To many people's chagrin, this is another place where chapter 33 seems a little wackadoodle, but if you have a 7-member board, the statute doesn't say in the case of a 7-member board, then you need 5 commissioners or 4 commissioners as a quorum. The statute just says 3 commissioners constitutes a quorum. So that seems kind of weird that maybe the minority, just having 3 people getting together could be a quorum. I think it would again take a modification of statute, and that has been in there for a long time. So I think people have contemplated changing the statute, but it just has not happened. So I just want to remind you all that we'll meet again a week from now to focus in a little bit more on those annual meetings, talk about some of the nuts and bolts of an annual meeting, but also talk about maybe some considerations that you have to take into account as we're still dealing with some public health issues, and people may be not comfortable getting together in crowded groups indoors. So we'll be fielding some questions and talking about what people learned last year at next week's gathering. So I want to open the floor to additional questions.
We had a couple questions in the chat. One from earlier, Dave Rip asked, our district bylaws call for the county rep to be chair. Is that okay?
I would think not. The statute says that the commissioners themselves select a chair, and that, like I said, that would happen on an annual basis. And you can't have a bylaw that's sort of contrary to the statutes.
We'll be getting into this one next week, Larry, but Larry asked, can a virtual attendee vote? And the answer to that would be no, in our opinion.
Mike, that would depend on which meeting they were attending.
Oh, that's
right.
Good point. Thank you.
Back up, Mike. If it's a commissioner meeting, and as you know, if the commissioners have all agreed that they're going to hold a meeting that accommodates fellow commissioners participating remotely, then the expectation is that they're voting as well, that they're part of that. And part of why that's possible is that there's no assumption of anonymity in the case of people voting as commissioners. If there's only 5 or 7 of you, everyone kind of knows what's going on. Trying to think of the other caveat there. There are the challenges of a commission meeting virtually really have to do with if you had reason to go in a closed session. That's where things get a little bit sticky. The state statutes generally allow local governments to go into closed session only for a narrow set of reasons. There are like districts that employ personnel, and so they have employees. And if they need to discuss highly personal matters related to an employee, they're allowed to go into closed session to do that. There's also times when lake districts may be involved in a financial negotiation, a purchase of a piece of property, and where if it was in open session, it might sort of show their cards in terms of how they're negotiating a purchase. So they're allowed to go into closed session for those types of things. If you're doing a virtual meeting and you go into closed session, it's not really closed, right? Because the person who's called in could have you on speakerphone. It could have 5 other attorneys in the room all taking notes. So I would just say that caveat. And I don't think that even happens that often. It's just something that I know my colleagues in the town government realm and the county government realm, they struggle with how to deal with virtual meetings. But in general, we'd say, yes, you can vote at commission meetings. No, you cannot virtually vote at annual meetings.
Say, Eric, this is Dan. Having attended a number of town and county meetings where they have gone into closed session, when they're doing it, the Oneida County and the towns up there that I have attended meetings, all have used Zoom. And so the host has placed everybody but the supervisors in the waiting room during the closed session, and then reopened the session, declared what the decision was from the closed session, and moved on. So, you know, it depends on what format I think you're using or what platform you're using, how easily it would be to move people into an area waiting room, virtual waiting room, so that they were not in attendance of the closed session. But it's a consideration. I mean, that's something that as a district we struggle with. We've not had to go into closed session, but we've thought it through.
Yeah, I guess my point is that if I were on that county board and I'm in closed session, none of you all know that right around the corner over here, you know, sits my attorney. And she or he is now part of our meeting, but you can't see or hear that person. So it kind of defeats the purpose maybe of thinking you're in closed session.
I think, and next week at the session that focuses more directly on meetings, I'm hoping to actually have someone along with us that will be able to speak directly to this. That's either an attorney or who has direct experience with the open meetings, the Office of Open Government for the state. I think a caution, and this alludes somewhat to what Dan Zimmerman's caution in his comments, is that it's going to be more difficult, especially now moving forward. The Office of Open Government was a little more lax in its standards, I guess. It allowed for more flexibility because of the pandemic and because of differing health orders in differing jurisdictions as to what as to how it interpreted what was reasonable under the circumstances. And so without those kind of things in play, we go back to a much stricter realm. So the rules may get harder to meet, but we'll talk more about that next week. Can you have more than one county appointee? If we have 3 lake districts in the county, can 3 different people be appointed, but only one on each district board?
Yes. So in the case, Tracy is from Portage County, and Portage County just has sort of a tradition that they've established over time to say, well, amongst all the county board members, someone's going to be appointed to the lake districts. And ostensibly that can start when if at one point the county only had 1 lake district. So it's like, oh, make that person the appointee to the 1 lake district. But then they got 2 lake districts, and they're like, well, let's just still make that same person the appointee to both lake districts. And now we have 3 lake districts. And it's like, well, okay, we're still making this one person the appointee to all 3 lake districts. You can do that, but I wouldn't recommend it, because you're asking that one person to go to a whole bunch of meetings on a regular basis. Now, if it was just 1 or 2, that's pretty reasonable. But as you start getting into 3 and then 4, it starts to be a lot to put on one person. And so the county in this case may want to think about being more strategic about making an appointment to a district that makes sense. Especially, sort of the bigger the county you get, the harder this is. So Marathon County is a fairly large geographic area. It wouldn't be fair to ask somebody to be driving to and from all around the county to multiple lake district meetings. So I think the more general situation actually is that multiple county appointees are made to multiple lake districts.
Eric, if I can kind of juxtapose what they do in Oneida County.
Sure.
The supervisors who are on the Conservation Committee are the ones that are generally appointed to the lake districts within Oneida County as the county appointee. There are enough lake districts up there that pretty much every supervisor on that committee has 2 lakes that they are appointed to. So they spread it around, but I foresee that as more and more lakes, create districts, that they're going to have to expand that, I think, beyond just the Conservation Committee and look at the entire board as taking the responsibility of appointing someone from the full board to these lakes. Because again, you're right, it becomes one supervisor going to 2, 3, 4, 5 different quarterly meetings for 2, 3, 4, 5 different lake districts. That gets to be a lot.
Yep. I want to show off this tool a little bit if you haven't seen this before. So on our webpage, Extension Lakes, we have what's called the Wisconsin Lake List, a directory of lake organizations. And using this, you can kind of specify where you're looking for. So if I say, I want to see lake districts in Waushara County, and I hit search, this shows me the roughly 25 lake districts in Waushara County. So again, the county has to make appointments to all 25 lake districts, and that's where it does start to be a bit of a stretch to figure out exactly who the people are. At the same time, I'm not sure if anybody from Waushara County is on this meeting, but I'm pretty sure that even though they have actually a relatively small county board now, they are still appointing county board representatives to play these roles. And they may go beyond what Dan mentioned, where they say, let's just use the geography of the districts and the geography of the supervisor districts to say, like, well, if you're the supervisor from over here, it doesn't matter if you're on the Land and Water Committee or not, because that's in your supervisory district, we'd like you to serve as the appointee to that area. other questions? Sarah put a link to the lake list in there.
Yeah, I don't see anything more in the chat, so if people have more questions, feel free to unmute yourself and ask them directly, or if you prefer typing, go ahead and do that too.
I left a message, everyone, but maybe Eric. In chapter 33, it talks about the relationship that the Lake District and the town should have. They should work together. And it clearly doesn't say there's any laws, the way I can read it, unless I'm wrong. But, you know, how do you guys interpret that that statement in the statutes? The relationship of the town or municipality with the Lake District.
Sure. I'm not sure where exactly you're saying that it needs to be completely cooperative. Is that what you're saying?
Yeah, I guess that would say. Yeah, how cooperative, that's a good one. How cooperative should the town be with the Lake District?
Sure. I mean,
Depends on who you ask, I guess.
yeah.
The town or the Lake District.
I'll read back sort of more to the intent of chapter 33 and how it was designed. You know, unlike the school districts and the county board, there was this idea that a Lake District would need this sort of direct connection to a local unit of government and to a county government. And so by design, it said there will be these two appointed members. And those members are meant, I think, to try to facilitate back and forth between the two groups to make sure that the town knows what the Lake District is up to and vice versa. And the same playing out sort of at the county level, that they're sort of ambassadors and emissaries. But like I said, they also serve as fully voting members of that board, right? So they're not just ambassadors, they're actually fellow commissioners. That being said, it's not hard to imagine times when the interests of the landowners and the residents of the district aren't fully aligned with the interests of the town board. And I think you just have to navigate those conflicts. I would say that at the state level, let's say, we've had numerous instances where a Lake District board does not agree with the State Department of Natural Resources. And similarly, there's ideally meant to be a nice cooperative relationship between these, where the Lake District and the DNR kind of see everything's eye to eye, but that's obviously not the case when there's court cases that sometimes go all the way to the Supreme Court that have the Lake District fighting against the Wisconsin DNR. So conflict does take place. It's really a question of leadership, maybe, of how you manage it when it's at a day-to-day meeting level, but it may require someone to say, well, we're going, you know, we don't want the town to do this thing to our lake. And so the Lake District does have the power to sue and be sued. And that power to sue can actually be a pretty powerful one when you think about cases like there was a big case in Lake Koshkonong in southeast Wisconsin. It can be
Lake districts suing a town or a
it can
municipality.
happen, yeah.
Mhm.
Hi, Joe. This is Dan. We've emailed back and forth and talked on the
Sure,
phone before.
sure.
Yeah, I can say that, you know, from our perspective, we've been very fortunate. Our county and our town, both towns, you know, view it Lake District as basically an owner-elector run government, and that the commissioners who are elected are the ones that are in charge of the board. We had a lot of support from both the county and the town. They came on board rather quickly with the way things are done for a Lake District. Have we disagreed on occasion? But it's always been amicable. You know, so I count ourselves lucky in that we've not had, because I've heard the stories from various parts of the state, issues between a district, Lake District, and a town, or Lake District and a county. You know, I think you just work towards being amicable. It's a lot easier said than done sometimes, I think.
We tried. We're trying. We're very much trying. you're not going to discuss voting ordinances in this session, right?
No.
Okay.
Well, I guess, I don't know, Eric, in,
In what way?
yeah,
How deep into the weeds do you want to get?
yeah,
Yeah,
we
you
can,
cover- you
we can
cover
break
it.
the surface maybe.
You guys already know something about this. What's the DNR? And I think I know the answer to this, but I want to get your take on it. What power does DNR have in approving local voting ordinances? The way I understand it, it's basically send it to us 60 days prior. We'll take a look at it. We'll make some suggestions, and then basically it's rubber stamped. I don't see a statute that DNR has to approve a local voting ordinance. To my knowledge, everything I've sorted through, the pamphlet you guys sent me. So
I'm pretty sure there is a statutory provision that requires a local ordinance to be approved by DNR, that's part of the local voting ordinance process. So we probably will,
Mike,
yeah.
that would be part of DNR's responsibility for any kind of shoreland zoning ordinance, wouldn't it?
Well, no, I think if it's a recreational boating ordinance, those are under chapter 30, right, Eric?
Yeah, you're right.
Yeah. And there's a specific procedure that has to be followed for a town to enact a local voting ordinance, or a lake district that's been given authority to enact an ordinance by the town. Sometimes the town enacts it on behalf of the lake district. But part of that process is that ordinance has to go through an approval process by DNR. To what extent that process in practice is a check off or an actual review, that's actually a good question that I need to look into and don't know the exact answer on. And my suspicion is that it might depend on the area of the state that you're in.
really,
I get that's only a hunch of mine. I have no actual data to prove that. I honestly don't even know exactly who in the department makes those decisions and whether there are different people in different sections of the state that are making that decision. But I've heard conflicting reports on how different ordinances have been looked at. That
the DNR warden for our area said there's no statutes on it. So that's what he told me. So I hope he's wrong, so that's what he said. We just
think
look
part
at
of-
it, make
I
some.
think part of the challenge is that there are some statutes that sort of set sideboards for what can be regulated as far as voting activity. And so they're trying to verify that the town proposal or a local proposal doesn't totally run at odds with some of those standards that are set forward. So here I put in the chat the link to Wisconsin water law. It's a slightly out of date publication, but not much has changed with respect to, I think, voting regulations that we're talking about. And so here we're on page 70. It just says, local regulation of voting laws specifically limited by statute. In general, you may enact ordinances as long as they're in strict conformity with those state statutes and rules. And so the challenge here is that there's, there could be hundreds of towns, each trying to create maybe regulations that are specific to dozens of lakes within the town. And the DNR just has to review them to verify that you're not running at odds with what's permittable by statute.
Okay, great, thanks.
And I'm guessing if we follow this footnote, number 94, I'm not sure how this document is set. Oh, there we go. So 94 takes us to 30.77 sub 3. So I'm guessing that hasn't changed. If you find 30.77 sub 3, it's going to specify out some of these things.
Okay,
And then not only statute, but also the state passes administrative code. And the code that's sort of on the books right now might get even more specific than what statute does. It gives administrative guidance to the DNR for how to follow these reviews. So
Okay, thank you. Thank you.
we do, so one of the future webinars that we're planning to hold, we're on May 20th, I believe. We're inviting someone from the DNR's voting regulations team to come join us. We want not just to talk about some of these sort of nuts and bolts things, but also point out that the state of Wisconsin does provide cost share money to local units that want to fund enforcement. So it's a way to try to stretch the dollar a little bit when it comes around to enforcement. And we're also going to hopefully be joined by a lake district or a local organization that has already participated in this funding. And so they know sort of how it operates for them. Because I have had calls of people wondering, because this is where the rubber hits the road, right? You can pass a whole bunch of rules. If there's nobody around to enforce it, it's not clear what the value is. And boating enforcement can be particularly tricky. So we want to talk about what that looks like in Wisconsin. I think last year things were a little bit tough because in many places we saw higher levels of outdoor recreation than most people can remember. And not everybody agrees on how recreation should take place. And some people were flagrantly violating the rules, even if they were just the statewide rules. So it's like, well, who's enforcing this? How are we supposed to even have some reasonable, safe use of the water body? So we're hoping to tackle a lot of those on May 20th.
Great.
Any other questions? Stop sharing. I'll just point out again, our plan is to record all these as well, keep posting them on the webpage. It takes a couple of days maybe to get them up there, but this one could be up there as soon as tomorrow, if not by Monday. We also see ourselves probably doing these types of meetings even more in the future, because again, it's a very large state, and these lake districts range everywhere from Douglas County to Walworth County, and meeting online sometimes does make things a little bit easier. So I appreciate all of you as well. Dan Zimmerman posted another thing in there. There's a, this is sort of a DNR publication. I think that's just a guidance for those voting ordinances, and you can find that online. I'm not sure if Mike or anyone's going to be quick enough to get the link in there. But I can include those two in the message, in the notes that I send out when we have the recording posted. So people are saying thank you, and I want to thank you all. The volunteers who run these lake districts, you're the unheralded heroes of our waters. You don't get enough appreciation, I think. So I thank you all for the time that you put into this and the work that you do. Thank you, everybody.